ત્યાં કોણ છે જેલમાં તમારે? હા, અમને કેમ ત્યાં પેલા એમઆરઆઈ માટે નથી લઈ જતા? હા હા, કયા ડોક્ટર સાહેબ? પણ અગાઉ જયારે સિવિલમાં લઈ ગયા ત્યારે એમઆરઆઈ નહોતો કર્યો એમનો? ચાલો કઈ ક્યાં લઈ ગયા બે વાર તમને નહીં?
Convenience compiling.
In ACB case 9 of 27.
9. I'm giving right now 9 because Your Honor said that first Your Honor will hear 9. So this is the compilation which we have made for the convenience of the person. So that we don't have to go to the chart sheet and the volume. It's translations. No, sir.
This is your discharge application.
That is my discharge application.
And also it's the same discharge application.
No, this is not a discharge application. It was not required to be signed actually. It's like just a compilation. It has, I'll explain. What I have done for the convenience of the court, the relevant documents which I want to rely upon in the charge sheet, my judgments which I want to rely upon, and my application also, copy of my this application also. Everything is in this compilation. So your lordship doesn't have to go to any other document. Sir, a plea was registered against me. Then our FIR was registered way back in 2022. There were in total 37 complaints against me, which was the subject matter of it. Almost every complaint alleged bribery. The investigation was done by CBI. CBI filed case number 3, which is before you. In respect of one complaint, that was the bribery of 3.98/4.98 lakh by Madhubhai Satya. For the rest of the complaints, this charge sheet has been filed. And in that charge sheet, all other complaints, either the IO has said that no evidence has been found against him of any offense, or he has recommended some kind of a disciplinary inquiry, which till date the government has not initiated against him. Only in respect of 3 of those complaints, which were of regularization of land in favor of the poor farmer, land encroacher, that I have been charged under section 409, read with 13(1)(d), which is now 13(1). 13(1), I'm sorry. So the charge against me is that there was property entrusted by the government to me. I have caused wrongful loss to the government, and it is supposed to be with dishonest intent. So I will just show the facts of the case. I will take one by one through all the allegations made against me. And my case is that it is a case of zero evidence. Number one. Also, the whole charge sheet doesn't show any extraneous consideration. And the third argument is that when I act under the Gujarat Land Revenue Code, the district collector acts as a judicial officer, and he's performing a judicial function, and he's protected by the Judges Protection Act. So, no criminal or civil proceeding can be initiated or can continued again. So these are my three legged arguments. I will first take your lordship through the facts of the case. Now the first, kindly see page 60. Sorry, 106. 106 of this compiled. This is a running page in page. This is part of the charge sheet. 106. What? So these are the.
What is your name, sir?
Amit Khemka. Amit Khemka. AMITKHEMKA.
Yes. Yes.
So these are the only three allegations. These are the three complaints, 25, 26, 27, about which this charge sheet has been filed. The first allegation of the IO is at page 110. He says that I had overridden the report of the Mamlatdar and in turn that of Chief Minister. And the report of the Mamlatdar is at page 110 of the report. The first allegation which the IO makes against me is at point number 5. 110, your lordship has?
Yes.
Process of allotment of land in question to the forest department is currently underway, and the proposal for this has been made in 2017.
In a moment, you are at page 110.
110 of my compilation. Running page 110.
Where are you reading, sir?
The very first, if you will see 1, 2, 3, 4, 5, 6, 7. It starts with 11/12/2017. The then Mamlatdar Angad submitted report by letter dated 20. So these have the compilation, not this. I'm sorry, this is discharge application. The compilation which I have given, I have given the today's compilation. First now see 106 of this. 106.
Yes.
These are the three complaints, sir. 25, 26, 27. In bold. In the middle of the page. So
Yes.
these are the three complaints that I have regularized land in favor of encroacher.
Yes.
So the first objection, first allegation which the IO makes is at page 110.
Yes.
Where he shows the report of the Mamlatdar. He quotes the report of the Mamlatdar at 110. And what he says is the Mamlatdar at point number 5. He said that the process of allotment of land in question to the forest department is currently underway and the proposal to this has been made in 2017. Now, sir, there is absolutely no document on record to show in the whole of the charge sheet that any such process is going on. On the other hand, I have annexed a document along with my application for discharge, which is at page number 140 of this compilation. 140, 140. Page 140, sir. Running page 140. This is a document of 28/11/2008. So the land for compensatory afforestation to the deputy conservator of forest, the translation is at 141. So, it is addressed to the deputy conservator of forest, wherein the collector Sujendra Nagar in 2008 refused to allot the said land to the forest department. So my respectful submission is that except for a false statement, there is zero evidence before your honor that this land was required for by the forest department or any process purpose. There is absolutely no evidence whatsoever. No witness from forest department, no document, nothing. It's just in thin air. The second allegation which he makes is also at page number 110. There is no number 6. There is no agricultural land in the name of the petitioner or their father. Therefore, the agricultural land cannot be given to a non-farmer for the purpose of agriculture. I do not know from where the Mamlatdar or the IO are reading it, because the GR under which the regularization is done, that is part of the record, and that GR is at page 123.
Can you repeat this argument?
I am saying, sir, he is saying that the land, it could not have been regularized in favor of these three persons
who were not agricultural.
who are not agriculturists. While we all know that these lands are given to landless people only. So there cannot be a land in their name, because it is for the purpose of the poor who are, if suppose a person was having lots of agricultural land, probably the allotment would be bad. But any case, the regularization is guided by the GR, and that GR is part of the compilation at page 122. That GR is 8th January 1980.
Yeah, this is page number.
Page number 122 it starts. The relevant portion is at para 7, page number 128. For regularizing the encroachments upon the land not falling under the instructions contained in para 6 above, if the land is encroached by any person other than backward class individuals, then at the time of regularizing the encroachment, 2.5 times of the existing market value of the land as penal occupancy price plus the revenue assessment and taxes from the date of encroachment up to the date of regularization shall be recovered, but from the backward classes and educationally backward classes recommended by Bakshi Panch on verification of their financial condition on recovery of not less than original market value plus the assessment and taxes, whatever. Where does it say that it can only be regularized in favor of agriculturists? Neither the Mamlatdar, nor the chief witness, nor the IO, they say under which rule, which law are you saying that? Now I'll explain where the confusion might have arisen. I don't know whether it has arisen. It is because under section 54 of Saurashtra Gadkar Tenancy Settlement and Agricultural Land Ordinance, it is a totally different law. This land is regularized under the Gujarat Land Revenue Code. That law is entirely a different law. Kindly see page number 173. I have annexed that section of the law. 173.
Whether there is any application, and any application of those people in whose favor land is allotted, whether it is part of record?
Yeah. It was remanded to him by the High Court where by setting aside the order of the revisionary authority, the special secretary revenue. The High Court had said, give them the hearing and pass a fresh order.
They have gone to the Mamlatdar.
But no, he being the district collector, got a report from the Mamlatdar and the witness.
તો કંઈક કોર્ટને એમ્બિગ્યુટી હોય તો હેલ્પ માટે ઉભો છું. I will not submit anything. પૂછી
એ ન કહી શકે એને કહેવા તો
Yes. So as a collector, he is the one who has to decide. It has been remanded by the High Court. Now, when it comes to him, he seeks the report from the witness. Witness in turn seeks the report from Mamlatdar. That report comes. He is not bound by that report. It is only for his own purpose. However, the IO goes ahead with the presupposition that as if the collector is bound by all those reports. It is all his internal thing. He is not supposed to deal with each and every aspect of whatever the Mamlatdar or the witness has said. if he doesn't find it of no consequence, it's not some kind of a, it is not a pleading taken by the opposite party that he has to answer everything. It is only for his administrative purpose, for his own consumption that he is seeking all that. But still I am answering everything. I am answering everything to the Honorable Court that there is absolutely no basis for all this. When they say it could only have been given to agriculturists, on what basis? Here I have annexed the order in another case where, with the consent of the state government, it was allotted in favor of a non-agriculturist, where the state government has given the consent. And sir, I will, after I take your honor through the merit allegations on merit, I will argue that just because this decision is wrong, let us presume everything is wrong. Just because this decision is wrong, that cannot make out a case under 409. If the investigating officers of CBI or police will start sitting in appeal, it's an appealable order. And that appeal can also be challenged in revision. And then it can be challenged in High Court. Nothing has happened. These orders stand. I passed these orders 7 years ago. Nobody has, the government has not challenged, not set them aside. So, who will decide if it is wrong or right? Are you? Why it is an appealable order? That is why I said, sir, it is a judicial act which is performing. Because it is appealable, it is revisable. It can be challenged in High Court. The Act provides for that. Still, I am satisfying the conscience of this Honorable Court that I have not done anything wrong. That is why I am taking your Honor's time to go on the merits. I don't want to just argue on technicalities and give an impression that I have done something wrong which I want to hide behind technicalities. That was all. Yeah. Now, sir, I have shown the GR. GR doesn't say anything. Then kindly see page number 173. Page number 173 of my compilation. Section 54. Page 173. Section 54 of the third tenancy settlement and agriculture. They were provided in this ordinance. No sale, including sales in execution of a decree in civil court or criminal court for recovery of land revenue, or for sums recoverable as arrears of land revenue, gift, exchange, or lease of any land, where lease is by law allowed or interest therein, or no mortgage, no other. Provided that the collector or an officer authorized by the government may grant permission for such sale on such conditions as may be prescribed. Now, next paragraph, state government provided further that no such permission shall be granted where the land is being sold to a person who is not an agriculturist for agricultural purpose. Now, sir, it is the case. Suppose I am an agriculturist. My learned friend is not an agriculturist. He can't buy it from me. That's it. This is the whole purpose of it. It does not mean that a landless person cannot be, who might be an encroacher, cannot be encroachment cannot be regularized in terms of the GR of 1980, it doesn't say so. That is not a sale. There, it doesn't say consideration. It says penal occupancy charges. Right? Para 7 of which I showed to your honor. It is not sale. So, Hamladar or Fitness or Mr. IO, they might be under an impression, but their impression is not going to lead this honorable court. They don't cite which law. If this is the law, then this law doesn't apply here. This is entirely a different law. And your honor knows it better than me. Mr. Modi would know it better than me because I don't study these revenue laws. But your honor has vast experience. So revenue code is for different purpose. This law is for different purpose. There is no interconnection between the two. And I have not performed any function under this act. And if we go by any logic, how can a landless person, how can a person who needs the help of the state to survive, to have his bread and butter, how can the law be like that? And the law doesn't say so. The GR doesn't say so. We are trying to read something else into it. Then your honor will kindly see at page 136, 135. This is an order by the Rajkot collector. If the Gujarati paragraph is fourth paragraph. Fifth line of fourth paragraph. At page 155. And the first line of page 136. Which shows that he regularized this land in favor of non-agriculturists. With the 136, which starts with 2, the very first paragraph on the top. So it clearly shows that the land was allotted in favor of, regularized in favor of a non-agriculturist with the concurrence of the state government. Concurrence is at 135, paragraph number 1, 2, 3, 4. So my submission is that while it is a clear-cut case that there is absolutely no requirement for these people to be agricultural. The IO alleges that in spite of the fact they were agriculturists, I regularized the land. Now the 107 of the compiler.
Yes.
Page one, running page one. So the next allegation IO makes it that the GR says that collector would, the government would first try to remove the encroacher. So he says, I made no efforts to remove the encroacher. Sir, kindly see page number 113. Last but one paragraph, 113, sir.
Why you pointed out page 107?
Sir, 107, if your honor will see, procedure for regularization of encroachment of land, it says as per GR under which I have regularized, the procedure followed for regularization of encroachment upon government land is as under. Removal of encroachment shall be the basic rule. So he says, I did not follow the basic rule of removal, and this very GR talks about the regularization later on. So he says, I did not remove, rather than I regularize. Now my submission to this is multifold. First, your honor will kindly see 113. 113. 113.
Yes.
It is revealed, a third paragraph from the top, it is also revealed during investigation that the statement dated so and so of the enclosure was taken by the revenue officers and Panchnama dated so and so was prepared. These documents state that the enclosures have possession of the said land for last 20 years. There is another Panchnama dated so and so prepared by Revenue Talati, in which it is mentioned that the enclosures had possession in question of the land in question since 1989. So the IO should have made all collectors from 1989 till date co-accused there. Because he says that and removal is the basic rule. मेरे केस में the matter went to High Court because my predecessor had refused the regularization without giving them the hearing. High Court didn't say, High Court did not give the direction, I will take your honor to the High Court order. High Court did not say that you remove them. High Court said that you give them the hearing on regularization. But IO Saab says that no, you should not follow the High Court order. You should have removed them. High Court is telling me that you have to give hearing on regularization after hearing them. But it's actually laughable. Then kindly see at 119 is the High Court order. Your honor has it. para 3. The basic prayer made in this petition is to the effect that the possession of the petitioner in relation to the land bearing survey number so and so, which is a government land, may be regularized. Record indicates that as such, what is challenged before this honorable court is the order dated so and so passed by the Secretary Revenue Appeals in revision application number so and so, which is challenged in special application number so and so, order number so and so, passed by the Secretary Department Appeals in revision, which is challenged in special civil application number so and so, passed by the Secretary Revenue Department Appeals in revision application number so and so. I quote, these top officials, none of them says that collectors have removed them. What the judge says, the High Court says later, the learned advocates for the petitioner have taken this court to the factual matrix arising out of the petition and have invited attention of this court to the affidavit filed in this petition. It is pointed out that in similar situated cases, the government has considered the possession of such persons and has regularized the possession. As such, noted by the authorities below, the land in question belongs to the government and the petitioners also intend to utilize the same for agriculture purpose. The learned advocate or the petitioner submit that the petitioners are ready and willing to undertake that it would not be utilized for any other purpose. Considering the fact that the claim of the petitioner is that they are in possession of the land in question since 60 years, it would be open for the petitioner to file an appropriate application before the respondent authority, which may be considered in the light of the prevailing policy of the government. It is further provided that while deciding such application, the petitioners be given an opportunity of being heard. High Court doesn't say that, sir, forget about regularization, remove them. These authorities of the state government who are sitting in appeal over the order, they don't say, but the CBI says so. And sir, what else could I have done? Except for considering their application, either I could have rejected or I could have allowed. Could I have done anything else after the High Court order? I have to only, that the direction is hear them. Either I could have said no or I could have said yes. I charged them almost two times of the circle rate for regularization as penal occupancy charges, for which I constituted a committee for pricing, for valuation. The valuation came to 25 rupees a square yard, but 22 rupees. I, as the chairman of that committee, fixed it at 25 rupees. The circle rate was 13. Here is criminality. Where is malafide? Where is extraneous consideration? We all know. If this is the way the order passed, I am saying not only, even presume that he is not a judicial officer. He is not performing a judicial function. I show that. Even if it is executive function, if this is the way that it will be challenged, that anybody can file a complaint and the person would be sent to jail, his entire career would be finished. Sir, I beseech this honorable court to come to this rescue of this officer. I am saying that he may have passed this order wrongly. But something more has to be shown than a wrong order. And here the order is not even wrong. It is wrong only according to Mr. Ayub, not according to the government of Gujarat, not according to the appellate authorities. They have not set it aside. Then, sir, the next thing Ayub Saab says is at page 113.
All these three order are of the same date.
Pardon, sir?
All these three order are of the same date.
No, they are they are at, nearby lands,
Near
same survey number,
the same date. This order.
same date, same everything. The same order was passed by the High Court.
Three orders.
Yeah.
After that, those orders are not chilling further.
Pardon, sir?
Those orders have not been chilling.
No,
None of the authorities.
no. This court is asked to go into it. If my order is bad, please pass an order. You are the appellate authority, you are the revisional authority, you are my appointing authority. And say it in the judicial order that we see that there was extraneous consideration. Hang this man. Nothing. You are leaving it to an IU of the CBI to decide this and to trouble this court.
No, I will not get trouble.
So this court is getting troubled, sir. If the case is just frivolous on the face of it, if it is on presumptions, IO does not cite any law, any rule, any breach of any provision. It is his feeling. I will show the next. That is completely his feeling.
Can I whether your order? Yes, yes, certainly. Whether your order was subject to approval of the state government?
No. That is one charge. I will come to that. Up to rupees 2 lakh. I'll kindly see page 113. of the compilation. Last but one paragraph. Last portion of the last but one paragraph. A financially weak person. I don't know what a financially weak person. Fourth line from the bottom of the last but one paragraph. A financially weak person cannot fight this very long battle from the office of Mamlatdar to the High Court of Gujarat. This shows that the encroachers were financially sound. That is why they could be able to sustain this long battle. But K. Rajesh did not even get the same verified and proceeded for regularization. So what he wants to imply that these people were financially sound and therefore the collector could not have regularized it in favor of the financially sound. From where does he read it? That it can only be done in favor of the financially unsound people. And what is financially unsound? What is the definition of financially not sound? That is why I said that he is going by his own, अपने दिल में कुछ आ रहा है उसको लिखता चला जा रहा है. कहां लिखा है जीआर में? कहां लिखा है किसी कानून में? Where is it? And sir, with all due respect, it is contemptuous. He is saying because I could go up to the High Court, that person could go up to the High Court. That is why you presume that he is financially sound. It is disrespect to the whole system. It is scandalizing the system. Is this investigation, sir? That because I could approach, I could reach up to the High Court somehow, or somebody could reach, so the collector should assume that he must be a rich person. The High Court is not meant for poor now. The Supreme Court तो फिर ultra rich के लिए है. Laughable. If this is the charge sheet on which the trial can go on, then sir, I have that order which I showed to your honor of the Rajkot collector at page number 150, 135. Para 4. What is the valuation, sir? 45 lakhs. Page number 135, para 4. The valuation of the land, which is the penal occupancy charges which have been charged from him, is 45 lakhs. In my case, it is less than 2 lakhs. What is this, are you seeing? The government is not getting into financial aspect. It is not deciding whether 45 lakh पे करने वाला अमीर है कि गरीब है कि फाइनेंशियली साउंड है. But IO साहब, without any definition, without anything, without any basis, implies that a person who could reach up to High Court also be rich. Then, sir, the last argument of last contention of IO Saab is at page 115, 115. This is the part of charge. Page number 115, Your Honorable. Most interesting. Kindly read para, fourth para, I will read with you. The investigation also disclosed that initially applicants had requested to regularize the encroachment of land of 2 acres. After due process, the cost of the said land had come to 2,02,350. As per the provisions of GR number 24, the collector is empowered to regularize the agricultural lands encroachments up to the area of 2.5 acres, and the amount of regularization is up to 2 lakh, 2.5 times of the land price amounting to rupees 5 lakhs. Hence, as per the provisions of this GR, this file was required to be forwarded to the Revenue Department for approval. But here Rajesh deliberately took the applications from the encroachers for reducing the land area so that the land cost comes under the power of the collector. The applicants in conspiracy with accused K. Rajesh submitted applications to reduce the land cost to 1 acre 38 guntas costing 197,280, which was well within the power of the collector. A person who fought for regularization of his land for 20 years from the office of the Mamlatdar to High Court and ready to pay 1.97 lakhs could not pay 5,000 rupees more. This was the deliberate act by Rajesh, done with dishonest intention and in conspiracy. With the above said 3 encroachers to bring this matter under his competence. Now, sir, let me ask you myself. If the applicant gives me an application that please treat my application not for 2 acres, but 1 acre 38 guntas. Where is my meeting of minds? Where is the evidence of my meeting of? Can I tell them no, 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 no? Either he will, I will do it for 2 acres, or I will not do it. Can I say that? We keep dropping prayers before your honor every day. Can this court say that either you take all whatever you are asking in your suit, or I will not grant you anything? This is my first leg of argument. My second leg of argument is that what is this IO asking this court to presume? There is no evidence. By this particular aspect, he is wanting this honorable court to give a finding of presumption of guilt. There is no evidence of 120B. There is no evidence of conspiracy. There is no evidence of meeting of minds. But this honorable court should send me to gallows on the basis of presumption. Now, sir, the most interesting part of it I will show you. At 111, page number 111. On 20/12/18, second paragraph, district level evaluation committee meeting was held under the chairmanship of K. Rajesh. Who all were the members? District Development Officer, RAC, Town Planning Officer, Surendra Mehta. In the meeting, the committee unanimously fixed the price at ₹25 square per meter. Now, sir, I will show the minutes of the meeting. At page, it starts at 142. The minutes of the meeting. At page number 143. Have you all got 142, sir? Sir, 143. There is a bold 2. What is the Suresh by? Suresh Lakwan. Now, of this subpara 2, land is, sir, 8094 square meters. Then it says that the kindly see subpara 2, the circle rate is 13. The recommended market price is 22. Has your honor got it? And then, sir, it is fixed at 25 under my chairmanship. Now, if my intention was bad, if I had some intentions, what I would do, sir? In place of 25, I'll make it 24. So the calculation will come down below 2 lakhs. My competency is 2 lakhs. The recommended price is 22. The market price is 22. I fix it at 25. 25 multiplied by 8094 is 2,02,000. But 24 multiplied by 8094 would have been 1,94,000. I could have done that. So there are so many. Where is my involvement in it? Except that this honorable court is being called upon to produce. And where is the loss to the government? 13 rupees is the market circle rate. The committee decides 22 rupees as the valuation at the market rate. I fix it at 25 rupees. And sir, उसका भी मैंने 2.5 lakhs 2.5 times charge किया. While the GR says that in case of backward people, you are not supposed to charge the 2.5 times of the market rate. It is only in the case of people who are not backward. These people are backward. It is admitted case of the part of everyone, of the IO itself. So I could have charged only 2 lakhs if I was hand in glove with them.
We can have a break here. We continue in the next session at the time. By that time, I will have some other work.
Highly obliged. That the applicant reduced the area, land area by 5,000 rupees and brought it within my competence, where it would not go to the government for approval. Now, sir, I want to show one letter at 149. of the compiling. So this is a letter issued by my chiefness with my approval, Agyanusar, Collector Shri Agyanusar, where the para 3 third line, para 2 third line, I demand an amount of rupees 2,02,000. What does it show? That I had no issue with this matter going to the government. This is what is my demand. This is what I have decided. So there is no intention of mine that it should not go there. But what? Maybe under legal advice, maybe the lawyer said that, Bhaiya, why wait for the government? Why go, take another 6 months? So you reduce your area. And in the next letter at 150, Your Honor will kindly see 150. they reduce. The applicant says that my need my application for 1 acre 38 guntas only. The rate is not changed. It remains 25 rupees a square meter. So where is my involvement in it? And where is the loss to the government? जितना जमीन दिया उसका पैसा लिया. Valuation is not challenged. It is nobody's case that the valuation was wrong or right.
Your order is dated 7/1/2019.
Yes, sir.
This application is certified subsequently on 16. Order. Page 149 is the order which you refer to.
This is the demand, sir. This is the demand. Order is at 154. This is the detailed order.
This application is subsequent to your demand.
Yes.
If you want to speak, you can inform me, but don't try to. Don't. If I don't know, I will ask you. That is, I will ask you. Whatever you want, you just convey to your lawyer. Yes, I will call and I'll ask you if I don't know. So, whatever you want to convey, you can convey to your lawyer, because you will be the best person during this program. Yes, but if it's the court only one person. Please sit down. Yes. So this application came to be subsequent on 16th of January, 17th of January.
Yes. So, sir, I did decide that this is the amount you have to deposit.
That was for the entire parcel of the registration.
Entire parcel of 8,094 square meter.
And thereafter, this gentleman, he reduced, I want only 1.30.
He says, I do not want that much land. I agree that there must be something he must have thought. He must have thought that चलो मेरे को टाइम बच जाएगा, मेरे को गवर्नमेंट नहीं जाना पड़ेगा, मेरे को चक्कर नहीं लगाना पड़ेगा अहमदाबाद का. Okay. But what can I do? Where is my involvement? मैंने तो 2,02,000 का डिमांड रेज किया सर. मुझे तो डर नहीं था ना कि सरकार के पास चला जाएगा. मुझे कोई डर नहीं था. Had I not raised this demand, one could have said कि आपने अंदर कुछ किया. I have demanded कि 2,02,000 रुपया, which shows that I was not afraid that it goes to the government. The IO says that the court should presume that because this person reduced the land area, therefore I was hand in glove with him to bring it within my powers. I mean, this is stretching it too much. Without having an iota of corroborative evidence, without even making an allegation that this is how I was connected with him, this was the benefit I was getting, this is why I was wanting to benefit him. क्यों करूंगा? मेरा कोई कनेक्शन नहीं है सर उससे. I have passed hundreds of such orders during my tenure. सर मुझे करना होता तो मैं 25 रुपया का 24 रुपया कर देता ना सर। 22 रुपया कमेटी बोल रही है कि मार्केट रेट है, मैं 25 रुपया डिमांड कर रहा हूं। 24 में भी ठीक था, जब मार्केट रेट 22 रुपया कमेटी बोल रही है और मैं 25 रुपया फिक्स कर रहा हूं, तो कोई मेरे को 24 में क्या बोलता सर, अगर मेरी इंटेंशन ये थी कि आ जाए इसके अंदर। So there are n number of possibilities. ये भी हो सकता है हुआ हो, ये भी हो सकता है हुआ हो, ये भी हो सकता है हुआ हो। But criminal jurisprudence does not run on ये भी हो सकता है।
Financial limit was 2 lakhs.
2 lakhs. मेरी पावर 2 लाख रुपया तक रेगुलराइज की वैल्यू की लैंड तक रेगुलराइज करने का था अंडर द जीआर विच आई शोड। Now, sir, the next allegation the investigator makes it at page 115. Bottom of 115. Investigation also disclosed that in all orders passed by K. Rajesh, a copy was shown to have been sent to Revenue Department, Gandhinagar. But in this matter, no order was sent to Revenue Department, Gandhinagar. He says in all orders, I used to send the copy to Revenue Department, Gandhinagar. Sir, not one such order has been placed before. I say it with all due responsibility on that. Not one such order where in the case of regularization of land, the order was forwarded to the Revenue Department, Gandhinagar. Not one is on the record. It is the regularization is of encroachment. Whenever there is a land,
There are various nature of power exercised by the collector,
yes,
which would require informing the revenue department.
but here, neither the IO points out that there is any law, there is any rule, there is any manual of procedure, or the GR says so, under which I am regularizing. He does not point out. The only ground he gives is that Rajesh himself used to send all his orders. So what will you do? You will place those orders before the court. कोई ऑर्डर नहीं लगा। मेरा आप ये बोल रहे हो कि क्योंकि राजेश अपने सारे ऑर्डर रेवेन्यू डिपार्टमेंट को भेजता था, तो इस केस में उसने नहीं भेजा।
One is saying or not.
He doesn't say. I was not. I was not. I was not. And I will show it. I will demonstrate from the order of my predecessor. I will demonstrate from the order of Rajkot collector, which I have placed.
Some because we are required to say more than that is the law.
With all due respect,
Because we are required to get approval.
because they reduce the land.
There are two categories. One, your power, your communication. One second, it is beyond your power. Whether it is India or whether it is right. After confirming, will help to service revenue department or approval.
If it is beyond 2 lakhs, then I will have to send for approval. But if it is below 10, but below 2 lakhs, then I will show to whom it has to be sent. And I have sent to those people who are concerned. I don't have to send it to the state government or the revenue department Ahmedabad. That is what it saying. Revenue department Gandhinagar. I have to send it. I have sent it. And I will demonstrate to whom I have sent.
I
One, nine. Are the officers or the authority whom I have sent. There I have kept it in my pocket. 50 collectors, that's about 159. मामला का एमपी मामला का इंस्पेक्टर ऑफ लैंड रिकॉर्ड तलाशी and the selection. So it is not that I have kept it in my pocket or I don't want anybody to know about it. This date I will show to your honor that my order would have been revised to also improved by the government. Even where the government is sending the complaints for investigation by CBI. The government is not saying that he is not sending to us. They have not set aside this order. They have found no infirmity with this order. Yeah. Does not say under which law this GRS, which regularization, which I told the 1980, yeah. It doesn't say that under which law the power of regularization. So I asked him, that how do you say that it is under the Gujarat Land Revenue Code? So we searched the law and we found a judgment of this honorable High Court. It is at page number.
सर को भी कॉपी दो.
Para 16 of this. Para of 1980, sir, this is at 1980. This is at page 120, which I showed the regularization is under that GR at 120. Para 7 of that at page 128. So now I'm showing your honor that this power emanates from Gujarat Land Revenue. And this is what the High Court says at page para 16. It becomes very clear from the scheme of the provisions of Section 61 that any person who has made an encroachment or who has occupied government land without the prior permission and right of the Mamlatdar as required under Section 60 can be penalized, directed to pay penal price, and also can be summarily evicted under the provisions of Section 61. Encroachment on the government land could also be regularized by the resolution of the government dated 8/1/1980, read with Section 62 of Land Revenue Code. This is the same GR. So the code says that this GR is an exercise of the powers under the Land Revenue Code of Gujarat. So now this I call upon this court to see as to what is the power of collector under Land Revenue. So the very first definition in Section 3 is of revenue officer. Every officer of any rank whatsoever appointed under any provision of this Act and employed in or about the business of the land revenue or of the surveys, assessment, account, or so is the revenue officer. Now, I am appointed, kindly see Chapter 2, Section 4. Constitution and powers of revenue officer. Constitution and powers of revenue officer, and Section 8 on the next page. The state government shall appoint in each district an officer who shall be the collector and who may exercise throughout the district all powers and discharge all the duties conferred and imposed on a collector or an assistant or deputy collector by this Act or any other law for the time being imposed. And so, my lord, collector is a revenue officer under this code. I have shown to your honor that this power was exercised under this code as a revenue officer. Now, why I am showing all that to your honor? To take your honor to Section 196 at page 170 of my compilation. 170 of my compilation.
formal or summary inquiry, 196. A formal or summary inquiry under the Act shall be deemed to be a judicial proceeding within the meaning of sections 193, 219, 228 of the Constitution. The office of any authority holding a formal or summary inquiry shall be a civil code for the purpose of such inquiry. So when I am performing a function under this code, I am performing a judicial function. And it is further strengthened from the fact, kindly see the page number 171, the very next page. Section 203. In the absence of any extra provision in the Act or of any law for the time in force, the boundary appeal shall lie from any decision or order passed by a revenue officer under this Act or any other law for the time in force to that officer's immediate superior, whether such decision or order may itself have been passed on appeal from a subordinate officer's decision, order or not. Then, sir, 211. Next page. The state government and any revenue officer not inferior in rank to the assistant revenue in their respective department may call for and examine the record of any inquiry of any subordinate revenue officer for the purpose of satisfying himself, as the case may be, as to the legality or propriety of any decision or order passed. So not only an appeal lies to my against my decision, it is a revisable order also. The government would have suo moto revised it, which the government has not done in 7 years. And the criminal proceeding has been initiated while my order is right. My order has not been challenged. And which is an exercise of judicial powers. The very fact, sir, that this matter had come back on demand from the High Court also demonstrates that I was performing